Hi everybody, Jennifer Schaus here. We're coming to you live today from Washington, D.C. and thank you for joining us in our webinar series as we cover the DFARS, which is the Defense Federal Acquisition Regulation Supplements. And our webinars are every Wednesday and Friday at noon Eastern. They are all no charge and they're recorded. So you can find all of the recordings along with 780 other government contracting webinars over on our YouTube channel. And the corresponding PowerPoints are found on slideshare.net. You can log into slideshare.net with your LinkedIn credentials or any other email address and get access to the PowerPoints, which oftentimes many of them have links in them. If you're looking to sign up for any of the remaining, I think there's 3 after today, for the DFARS, just navigate over to our website, click on the section called the DFARS. You'll notice on the left-hand side, we actually covered this same series back in 2021. However, the difference is things have changed over the years and they continue to change and evolve. So just be cognizant of what has happened in the past and what is current, but still has a heartbeat and is evolving present day. A little bit about us. We are based in downtown DC, as I mentioned, and provide a variety of services that you see here on your screen. You can find more about us on our website. But our main focus is actually helping companies get onto the GSA schedule. This has become more important with the executive order that dropped March 20th. 14240 is the executive order number. You can learn more about that over on the Federal Register, but the emphasis is to steer most of the government procurement under the GSA schedule. So if you want to get onto the GSA schedule, we can help you with that. In the event that your company is selling to federal contractors, so the banks, law firms, payroll, insurance, healthcare, the whole 9 yards, we do offer advertising in our newsletter as well as sponsorship in our events. We do have an event coming up on October 8th. It's the Comic-Con conference, which is compliance in contracting. It'll be held over at Carasoft, and we'll send out information along with today's recording on that. In the event that you do want to advertise with us, we reach over 38,000 subscribers, most of which are government contractors. We do have a summer special, which gives you a 45% discount if you purchase in bulk, which would be an ad that would run from August 18th through December 29th. We offer 3 payment options on that. If you want information, just send us an email and we will send you our media kit. Now we want to thank our in-kind sponsors, our friends over at govevents.com. That's the premier platform for posting events related to government and government contracting. Find all of our events and our webinars and our recordings over on govevents.com. Also, the Fairfax County Economic Development Authority has an online database, has an online calendar for events and webinars in the local DC metro area. You can find, again, all of our events and webinars over on the Fairfax County EDA calendar. Also, setasidealert.com is a publication that sends out RFPs, RFQs, RFIs for the set-aside community. That's small women-owned, veteran-owned, hub zone, and all of the others. So visit setasidealert.com for more information. We also want to thank the Virginia Apex Accelerator. That's a trusted DoD-funded organization. They provide local training, counseling, and mentoring for aspiring government contractors, as well as matchmaking events. If you want to sell to state, local, or federal government, please contact your local Apex Accelerator. You can visit the links on your screen to review the training calendar, locate free resources, and to schedule an appointment with a Virginia Apex Accelerator counselor today. Okay, we also want to thank our paid sponsors, which is what allows us to put this series on at no cost to you. So CMMC comes to us from our friends over at C3. C3 is CMMC Cybersecurity Maturity Model Certification. C3 suite of CMMC solutions include C3 Command, C3 Catalyst, and C3 Core. These solutions answer the needs of every defense contractor, whether your CMMC priority is a fast-defined path to compliance or you need the flexibility to manage multiple environments. C3 offers solutions. They are your partner with the deep expertise in IT, cybersecurity, and compliance. Visit c3.com or c3isit.com for more information. Workplan is an online contract management and accounting tool Designed for federal contractors and hosted by Amazon Web Services. Get and stay DCA compliant, manage expenses, timekeeping, and forecasting. Plus, use the work plan platform to manage your capture process and your CRM. Contractors can integrate their HR and payroll into this one easy-to-use solution. Contact Work Plan today. Ateria. Ateria specializes in Microsoft Cloud licenses and services for government and contractors. They provide a business advantage for Microsoft Government Cloud licensing, managed IT administration, and security, as well as data intelligence services. They implement secure, compliant, and scalable solutions to enhance operations, reduce risk, and uncover opportunities. Contact Ateria for expert IT assistance. Gov White Papers. So last but not least, Gov White Papers. They are the central hub for government and government contractors to find and post content geared towards solving public sector challenges. With your free membership, you can add relevant white papers, case studies, data sheets, and more, making your content available to a wider audience. Do you have the expertise but not the content? Gov White Papers can also create materials to meet your specific needs. Join for free today at govwhitepapers.com. And I realized somehow we missed a slide, or a slide got wiped out in the process, but our friends over at BidSpeed, the BidSpeed platform allows users to search public sector opportunities at the federal, state, and local level. Users can also find anything from a compliance matrix to teaming partners, incumbent point of contacts, expiring contracts, and proposal templates. Discover, manage, and secure government contracts with BidSpeed. BidSpeed is an official partner of the SBA's ETG Empower to Grow program. Contact BidSpeed today. Okay, we apologize to BidSpeed for that. And now we're going to dig into the DFARS Part 250, which is Extraordinary Contractual Actions. Paul Hawkins is our speaker. He's with Gentry Locke, and I'm going to let him take over the stage here and let Paul explain a little bit about himself and his firm. Paul, we're excited to hear your presentation today, and thanks so much for taking the time to put together the slides and sharing your time with us today. The floor is all yours, and I'll just wait for you to tell me when you're ready for your next slide.
Okay, great. Thank you so much. Jennifer, can you hear me well?
I can. Thank you very much.
Good. All right. Well, thank you. Good afternoon to everyone that joined. Happy to be here to present on DFARS Part 250 today. As Jennifer said, I'm with the law firm Gentry Locke, based in Virginia. I'm actually physically based in Southeast Virginia, but have represented government contractors across the state, up in Northern Virginia, and then throughout the country that just do business with mainly the federal government and state and local governments, and kind of have specialized in those issues. My practice is focused on kind of being outside general counsel to government contractors and dealing with their compliance obligations, other business and commercial issues, and then some other special representation like bid protests and things like that. I enjoy doing these types of presentations. In fact, Jennifer mentioned Apex earlier on an earlier slide. I'm actually presenting with the GMU Apex Accelerator a week from today. So if you're interested in that, I encourage you to go register for that as well, if I'm okay to plug that. I enjoy working with those folks over there, and they're a great resource, as she said previously. Next slide, please. Okay, kind of jumping right in the topic, we're going to be talking about extraordinary contractual actions today. As the name kind of implies, I say there, it's a rare, but it can be a potentially powerful mechanism for contractors to seek contract relief from agencies. But it's important to understand that this is not a right that you have, but it's as a previous court has said, it's an example of administrative grace. It's something that a specific statute has provided that allows, in very rare circumstances, monetary and other types of relief to contractors involved in national defense. And as we'll explain more in later slides, understanding this nuance is really important to understanding what this avenue of relief can really be available. It's not necessarily, again, to remedy contractual breach or anything like that, but in certain circumstances, it can provide some pretty powerful remedies from the government to the contractor. And while it is rare, and while it is kind of an interesting kind of niche that's often overlooked in the FAR and the DFARS, it's something that contractors, especially kind of in the DoD contracting space and everything, should be aware of, because it may be kind of an idea out there that when you feel like there's specific circumstances where you may not be able to get relief from the government in the normal channels, you could at least consider if extraordinary contractual relief is available to you in that circumstance. Next slide, please. Before we jump into the DFARS section that we're talking about today, it is important, I think, to understand some of the history and background here. The authorizing statute for DFARS Part 250 is this statute that was passed, Public Law 85-804. It was originally passed by Congress in August of 1958. So it's not a new statute. It's something that's been around for a while, and it was actually rooted in prior World War II era statutes that address this unique potential relief needed by contractors and their supply chains during the war. And in fact, specifically in 1941, the War Powers Act, Title II of the War Powers Act to be precise, was passed to ensure that defense contractors could continue to perform certain vital contracts in connection with the war effort, despite potential economic challenges. So in other words, the government was trying to provide some type of way that if a vital contractor could not continue to support the war effort, that the government could step in and use its power to essentially keep that source available during the war. After the war, a similar law was passed, the War Contractors Relief Act in 1946, which allowed for contractors to submit claims that would have otherwise been available to them to submit and for the government to consider, except for obviously the end of the war and the surrender. So this allowed for some special relief for those contractors that may have had residual claims after the war. Some of these types of laws were extended during the Korean War, and then ultimately it was sort of made permanent in the 1958 statute, and that's where we get these particular sections of the FAR and the DFARS, which is the supplement to it, obviously. Next slide, please. Talking a little bit more about this specific statute, again, the purpose is to provide contract relief that, quote, facilitates the U.S. national defense. So that's kind of the background purpose of the statute. It's not used to satisfy claims against the U.S., and and importantly, its primary intended beneficiary is the government itself, not necessarily the contractor. So that's a theme you'll kind of see over these next few slides, that while the contractor is getting oftentimes monetary relief, and in some cases hefty amounts of monetary relief, the beneficiary is really the government, and sort of keeping a certain source open, keeping them from going into bankruptcy or something like that is really what the purpose of the law is. Only certain agencies are actually allowed to use this type of authority. Several different agencies and departments throughout the government have been granted this authority over time, and so for our purposes, most, if not all, the agencies that you would likely be working with have been granted this authority. Further, there are further authorities that the president can then delegate down to each of the secretaries of defense, Army, Navy, Air Force, or their duly authorized representatives. So there are mechanisms to kind of further delegate the authority for approving these types of requests that we'll talk about in the next few slides, and so forth. Again, the authority to grant this relief is conferred to the president, but he can in turn delegate that authority down to others, and that includes the establishment of something we'll talk about soon, the contract adjustment boards, which are kind of the ultimate arbiters of these types of requests. Again, the authority is not necessarily granted to contracting officers or the boards of contract appeals, as you probably may know a little bit about through through the Contract Disputes Act. So typically the warranted contracting officer is the individual that has that authority to issue final decisions on claims, and the Board of Contract Appeals or the Court of Federal Claims are the arbiters for appeals of those decisions. And that's not necessarily the case here. It's through these boards and other levels of authority that the Act has specifically outlined. Again, where we think about sort of what does this necessarily mean that the relief has to facilitate the national defense, one example of where a contractor was granted extraordinary relief, I think kind of illustrates this point. It's an older case back in the 1980s, but this particular contractor had supplied personnel vehicle-mounted radio equipment. They had a series of contracts that kind of extended back into the 1960s, but ultimately they faced financial difficulties that threatened their viability. They submitted a request for an adjustment of their contract that would have essentially doubled their unit prices, but otherwise they would not have been able to continue to be a viable contractor for the Army. And ultimately, the Contract Adjustments Board, we'll talk about some of this later about this essentiality to national defense determination, but they found that for existing and future contracts, because they were only one of two suppliers for this specific type of radio. And in fact, they were the sole domestic producer. And because the board found that that they were such a critical sole supplier, they were granted most of the contractual relief that they sought. So I think as you kind of think about how the Contract Adjustment Board assessed how they were essential to national defense, that kind of gives you an understanding of when a board may find and grant the types of requests that you can submit for under DFARS Part 250. All right, next slide, please. All right, so jumping right to the specific part we're talking about today, is DFARS Part 250 implements the statute we were just talking about within the Department of Defense. It supplements FAR Part 50. So I think if you've been listening to this series, you understand that different federal departments and agencies have their own FAR supplements. Obviously, the DFARS is the DoD supplement, and you can see the pattern and the numbering. So FAR Part 50 covers extraordinary contractual relief, implements Public Law 85-804, and then DFARS Part 250 supplements that. And so while we're talking about the DoD processes specifically today, FAR Part 50 is still applicable, and FAR Part 50 would be applicable if you were having to go through other departments that again that the president has conferred this authority to use this type of relief under. DFARS Part 250 kind of generally, it outlines the processes for seeking relief under Public Law 85-804. It creates contract adjustment boards, as we just talked about, for each of the military departments. Specifically, the wording on that is that the departments of the Army, Navy, and Air Force each have a contract adjustment board. This is in DFARS 250.102-2 to be more precise. The board consists of a chair, not less than two nor more than 6 other members, one of whom may be designated the vice chair. They have a quorum requirement. Alternates may be appointed, but ultimately, this board that's set up is there to consider and render decisions on a request under this extraordinary contractual relief. There's a special indemnification provision that falls under Public Law 85-804, which we'll talk about just briefly at the end, because I think it's more it's not sort of the main thrust of DFARS Part 250, but it's something that you should be aware of. It includes that within DFARS Part 250. And then the DFARS PGI Part 250, which is another corresponding set of guidance, it outlines more of the specific procedures internally to the DoD and to defense agencies for receiving, reviewing, and then disposing of the requests that come under DFARS Part 250. It should also be noted that there are different delegations, for approval authorities for different amounts, and that those have been sort of delegated further down in acquisition guidance. And so they're going to be kind of specific to each military department or defense agency. And I think the takeaway there is that if you're going to submit a request for extraordinary contractual relief, you would want to confirm some of those specifics depending on the agency or the military department that you're submitting to. Okay, next slide, please. All right, just kind of walking through the process for requesting relief from DFARS Part 250. It's a fairly straightforward process, actually. You know, as you'll see, there's not a lot of steps here. There are not a lot of really, you know, there are not a lot of pitfalls and deadlines and things like that you may find in the bid protest process or the Contract Disputes Act process. But nonetheless, there is kind of a set out a timeline and a certain process that you have to follow if you're going to submit for extra contractual relief. So first, the contractor would submit to the procuring contracting officer, or if that's impractical, there are other avenues you can submit to initially, your initial request and the backup that you have for that. After receiving that request, so that contracting activity will then prepare the record, and then they'll forward it to the appropriate official within 30 days from the close of the month in which the record is prepared. And so the agency, once you submit that request, the agency is permitted to investigate. They can come back and request additional information to establish the necessary facts so that they can then submit up their recommendation and forward this all ultimately to the Contract Adjustment Board. Next slide, please. So what goes into a request under this DFARS part? So it outlines that a contractor's request for extra contractual relief should, at a minimum, and I just want to emphasize there, at a minimum, include the precise adjustment requested. So we'll talk in the next few slides about what are the different remedies you can be provided under this section. So you need to very clearly outline the precise adjustment you requested, the monetary amount or the specific contractual implementation that the agency will need to take. You need to outline the essential facts related to the request. They need to be organized chronologically in narrative form. So again, this is going to be kind of a submission, I would say somewhat similar to when you submit a claim to the contracting officer, but not necessarily the same, but you can sort of see that you're generally following a lot of the same types of information needed. You can include conclusions based on those facts. You can include argument in there about why you believe you should be conferred the extra contractual relief. I think I just want to emphasize here that, this is something that's being submitted to the agency. It's different. It's something that is not in the normal course. It's an additional consideration that the agency is going to take. And so that initial submission should certainly be thorough. It should have all the information needed to address all the arguments one would have to make to be conferred the extra contractual relief. And I would just recommend, as self-serving as this probably sounds, you should engage an attorney in that process, familiar with procurement law, to just understand and help you assess sort of the strength of your potential request, and then address a lot of those potential pitfalls and issues up front. And then lastly, sort of like a claim, if the request exceeds the simplified acquisition threshold, it must contain a certification in that request that it's been made in good faith, et cetera. So, okay, next slide, please. So talking a little more about the process here, the activity will then forward the full record and its recommendations to the Contract Adjustment Board. It could be that the activity will require the contractor provide other information. There's different types of things. They may come back and ask for more financial backup. They may ask for more information about the company generally. So if there's going to be this essentiality to defense determination, they may request more information. And again, as I said in the previous slide, the more thorough and airtight your initial request is, sort of the easier it is for the agency to push it through and approve it. But they can come back with additional requests for information to include in the record that it's going to submit up to the Contract Adjustment Board. It's possible that they may need to coordinate with other departments and agencies, especially in the essentiality determination, because if you are a contractor for, say, multiple defense departments or agencies, the agency may need to get a better understanding of that work you're doing. So ultimately, that's forwarded to the Contract Adjustment Board, and the Contract Adjustment Board issues a memorandum decision. It's, and that this decision has to have certain components to it. So essentially, they're going to outline the facts that they reviewed, and then the basis of their ultimate determination and what their decision is. These are not generally subject to appeal or review, and the CAB may either approve or deny the request. So it's not something like a claim under the Contract Disputes Act, where once you get the final decision, you can then appeal that to a Board of Contract Appeals, or take that to the Court of Federal Claims for them to review the contracting officer's decision. The CAB is going to essentially review your request and either approve it or deny it to see if it should be afforded that under this statute. And then finally, of course, the decision is forwarded to the appropriate contracting activity for implementation. There may be additional wrinkles there with funding and things like that, but essentially the CAB is going to forward that decision back to the contracting folks to amend the contract or to issue payment or what have you to implement the decision. Next slide, please. Okay, so overall, there's essentially three types of relief available under DFARS Part 250 and under this implementing statute. So first, under DFARS Part 250, you can be issued a contract amendment without consideration. So in other words, again, what's going to happen here is that the government can modify a certain contract you have to add more funding to it to give you this requested relief that you need. So first, and that can either happen for one of two reasons. One, the contractor is, again, essential, quote unquote, to national defense. So that can provide the basis for an amendment without consideration, or there is a determination that there was an unfair government action that caused a contractor loss. And again, it can't be merely a decrease in profits, but it actually has to be a loss from the contractor. So more under that fairness piece. Again, it has to be a loss, not merely a decrease in profits. It does require a determination that the adjustment is in the interest of ultimate fairness. The contractor and essentially the board has to see that the contractor suffered actual loss under a defense contract. The government action was the cause of the loss, and there was sort of manifest unfairness to the contractor. And it's not, and again, you would not otherwise have a remedy available to you under the Contract Disputes Act. So one example of this in a past case was essentially the Army had a need to lease a building. They encouraged a certain contractor to do that. The Army, made certain promises to that contractor that it would sublease the property, things like that. However, the Army regulations wouldn't allow for that. So the contractor had relied upon these representations from the Army, and then ultimately, the contractor was obligated to the building owner for this lease that it had entered into, kind of at the Army's urging. And when the Army then couldn't make good on its promises, really the only way that the contractor could get relief for that unfair action was to go this route under the contract or extraordinary contractual relief, which it was granted in that specific instance. This idea of essentiality, which is one of the other bases in which you can be issued an amendment without consideration, that's where, again, the Contract Adjustment Board is going to look at issues like, like what the example I gave earlier about, are you a sole supplier of a certain critical component? One other example, kind of very similar to that, is there was a contractor that was contracted to supply bombs, and then when material costs increased sort of exponentially, 40+%, the government continued to exercise those options, which was just economically not feasible. Essentially they went this way of extraordinary contractual relief and was able to get relief there. And so again, but because of the critical nature of that contractor was a determination the board had to make before they could go forward with the relief. You can also you get relief for correcting mistakes. So if there's a mistake or ambiguity that consists of a failure to write the contract as both parties intended and understood it, or if there was a contractor mistake so obvious that the mistake should have been apparent to the contracting officer, or if there was a mutual mistake of material fact, in those types of instances, you can go the route of extra contractual relief in order to get the contract mistake rectified. An example would be, if there was, an over 22% disparity between an awardee and the next lowest bidder, and the contract was written, the mistake was included in the contract, getting that reformed is something you can go the extra contractual relief route to get. And then lastly, the other area where you can have an availability for relief is formalizing informal commitments. So this would permit payment based on an action the government took without a formal contract. So, a contractor relies on an agency official instructions in good faith, and again, you typically would not have a legal remedy there, but if it ultimately facilitates the national defense by ensuring fair treatment and prompt payment and things like that, you can go this route and get extra contractual relief. So again, no matter what the basis is, it has to ultimately facilitate national defense, and the position of that contractor that's requesting the relief must apply. Next slide. So in addition to that, and apologies for some duplication there of the bullet points, but in addition to that, there is this mention of, quote, residual powers in FAR Part 50 and DFARS Part 250. And that's just really a catch-all where, national defense may be otherwise facilitated. There is a way that you could still utilize this authority in addition to what I described earlier. So one kind of very rare example there was where a 6-tier subcontractor actually, so a contractor that didn't even necessarily have contractual privity with the government, was granted relief because it was the only qualified supplier of critical rocket booster parts, and it was facing closure of its manufacturing plant, and for various reasons, and they were actually able to seek out extra contractual relief from the government to ensure it could continue its operations. And so again, the department was able to look to its, quote, residual powers for that. And then lastly, there is this other area where you can use this process to request indemnification provisions in certain contracts, and we'll talk about those kind of towards the end. Next slide. So what are some of the kind of the limitations on this relief? I mean, some of this is things that you would address kind of in your submission, or these are areas where the Contract Adjustment Board is going to do its analysis to see if the relief is appropriate in a certain circumstance. We've already said this earlier. All relief has to ultimately facilitate the national defense, and so if it's not going to do so, then your request would be denied. Again, if you're one key piece of analysis, if you're asking for a contract amendment without, or a modification without consideration, you're just asking for the additional monetary relief, and you're not in that area of unfairness, you're going to have to demonstrate your essentiality, quote unquote, to national defense. So that analysis is focused on the contractor. Again, think about the examples I've given so far. It focuses on, what part they play in the defense industrial base and in the national defense process. The agency, that ultimate agency determination. So again, remember, you submit the request to the contracting officer, and then that contracting activity, that agency you work with, is who that's the level that puts together the record that the contract adjustment board will review. Their ultimate determinations and how they put the record together is going to be afforded substantial weight. So they're going to be sort of that first line of defense in determining whether or not you, as the requester, meet that threshold requirement of being essential to national defense. Mentioned earlier, kind of like the bomb manufacturer or the rocket part manufacturer. So these types of things that those are kinds of things they look at for essentiality. Another area is that may provide a limitation on your ability to seek relief here is that if you already have relief available to you under the Contract Disputes Act or some other legal authority, if you have that, you're not going to typically be able to seek out extra contractual relief. So in other words, if what you're trying to ultimately rectify can be done through the normal claims process, you're not going to necessarily be permitted to go, or your request is going to sort of ultimately be denied because you can seek out the Contract Disputes Act process. Now, there is a little bit of an exception to that. If the Contract Adjustment Board determines that that type of relief available is not adequate, or it's lacking in some way, ultimately, then the Contract Adjustment Board can still go forward and grant your request for extra contractual relief. So an example there was, where a shipyard, sort of critical to national defense, the Contract Adjustment Board deemed the appeals process and the claims process to be so lengthy and complex that in order to get the relief to the contractor that it was needed, the Contract Adjustment Board still sidestepped that and sort of granted the relief. So that was probably a very specific circumstance, but there are these times where that other legal authority may be deemed lacking or inadequate, and therefore you could seek out the extra contractual relief. There is a process for congressional notification and opportunity for Congress to weigh in on this, but it's only for large amounts. So that threshold is now $150 million. And then lastly, the statute does speak to it only applying during wartime or declared national emergency. But to make a long story short, the way that certain follow-on statutes and things have played out, that's a largely kind of meaningless limitation. In other words, this relief is now sort of generally available to contractors, and it's enshrined within the FAR. Next slide, please. Talking a little more about the relationship between the Contract Disputes Act process and DFARS Part 250, because I do think that for contractors sort of on the ground, this is kind of where this is probably going to come up the most. So a contractor is probably going to be looking at their options. Something has happened within their contract performance and payment issues. And so the contractor is then sort of weighing what options do they have. Can they submit a claim? Is this particular avenue of relief available to them? And so sort of understanding how these processes play against each other is important. So because you can have your request here denied based on your failure to exhaust those remedies or to, again, have those other avenues of adequate relief. We talked already about the example where the Contract Disputes Act process was just too lengthy and complex to provide the contractor with the relief they needed. That can occur. But essentially, if you have the general rules, if you have if the relief you're seeking is available under the contract, so in other words, it's the result of a specific breach of contract, you still need to follow the Contract Disputes Act process of submitting a claim to the contracting officer, awaiting a final decision or a deemed denial, and then pursuing the appeals process if required. We said this earlier, the Contract Adjustment Board decisions, they're not reviewable by the Board of Contract Appeals. So the processes are mutually exclusive of one another. You essentially have to live with the Contract Adjustment Board's ultimate decision. But in certain circumstances, the courts and the boards do have a jurisdiction of matters related to this. So, for example, if a contracting officer just repudiated and did not implement a CAB decision, that might be something that you can take up in the Contract Disputes Act process and the appeal process. We talked about this earlier, that part of this DFARS part allows for the inclusion of certain indemnification provisions where the government would be required to indemnify the contractor in some very specific circumstances. So if there are issues in interpreting that clause, in determining entitlement to relief or things like that, or if the contracting officer excludes the clause from the contract, those types of things, because they arise out of the contract itself, can be pursued through the Contract Disputes Act process. Okay, next slide. All right, so this kind of special indemnification that we've talked about overall, this is another part of the extra contractual relief you can provide. And so if you're dealing with a contract that has, quote, unusually hazardous or nuclear risks, you can request that this particular FAR clause that's outlined here be included in the contract, or the contracting office can determine if this particular clause should be included to address the work being done under the contract. This FAR Part 50 section that outlined here outlines those particular procedures. And again, it's just a limited circumstance where the government would be on the hook essentially to indemnify the contractor for certain types of circumstances where that indemnification would be appropriate. And so again, this is also part of this DFARS Part 250. And I mean, very generally, that kind of covers the ground on this specific section of the DFARS. As I said earlier, the process is pretty straightforward. The submission is pretty straightforward. Where I think the nuances hit is where a contractor that may be, sort of incensed by some issue they've been dealing with a defense-related contract, where they potentially feel like the government, owes them a lot of money, or there's some real disputes that are arising between them and the contracting officer. It's worth exploring whether this particular avenue of relief would be available. And I think that's where the nuances of this section really arise. Again, because it's a pretty rare thing. But if you are in that, if you are in the defense space, it's something you should keep in mind, that when some of these more extraordinary situations occur, you can potentially look to this to get the relief you need. And in many cases, it's when there's some dire circumstances for the particular contractor, if you think about the examples I was giving earlier. So again, pretty straightforward, but it's something that I think contractors should certainly be aware of. Next slide. Kind of lastly here, just wanted to address, folks are certainly aware of the FAR revolutionary overhaul that's taking place. So I think it's worth noting, whenever you're going through these DFAR sections, sort of what's the specific, where are we at in the process as it applies here. Last time I checked it, which, I don't know, unless they updated it this morning or something, last time I checked, FAR Part 50 has not yet been revised with model deviation guidance. So you may or may not be aware of that. What's happening is the FAR Council, sort of pursuant to the guidance and the executive orders coming from above, are going through FAR part by FAR part to make revisions to those parts of the FAR, and then they issue what's called model deviation guidance that the agencies will then implement on their own. So, as folks are probably very aware here, the overhaul mandate is an effort to streamline regulations and focus only on statutorily mandated provisions. I can't predict, how far Part 50 or DFARS Part 250 will change with the FAR overhaul, but I can say that it's not a part of the FAR that I think really kind of falls squarely in the mandate here for increased efficiency, and it's really kind of very focused on just implementing this statute, and so it may not change very much. The only adjustments I could see happen is there could be adjustments to some of the procedure and some of the other delegation authorities and things that aren't explicitly spelled out in the statute. But I would, I may be wrong, but I would predict that FAR Part 50, DFARS Part 250 will likely not change much due to the FAR revolutionary overhaul. Okay, well, that's all I had on this particular topic. I think they while we're not entertaining questions here, I think if you want to reach out to me in an email, I'd love to connect with you. Find me on LinkedIn, etc. And if you want to discuss this topic or anything else more, I'm always happy to do that. And very thankful and appreciative for the opportunity to be with you all today. Thank you for signing up, and hopefully you all found this to be informative and educational, and maybe ultimately useful. Thank you.
Paul, that was a great presentation. I enjoyed it. Appreciate your knowledge, in-depth knowledge of the topic. And yes, again, if anybody has questions about DFARS, defense contracting, government contracting in general, Paul's great, and I would suggest working with him. So you've got his email address here. Contact him directly, and we'll get the recording and slides out to everybody within about 24 hours. In the event that you are actually watching this over on our YouTube channel, give us a like, leave a comment. We would love to hear from you. If you're not subscribed to our channel, please do so. It doesn't cost anything, and you'll actually get alerts anytime we upload new content, which we did yesterday on the topic of GSA schedules, and then one the week before that also on GSA schedules. So again, thanks to Paul for a great presentation and sharing his time with us today. And thanks to everybody who joined us for the live presentation. Have a great day, and then we'll pick up on Friday of this week and Wednesday and Friday of next week, and that will be a wrap on the DFARS. So thank you.